What about a warranty deed? My grandmother and my dad have had a warranty deed for the property set up for several years now, but we just found out that she's changing her will to split the property 3 ways. Okay, so I'm not exactly sure if this question is asking this, but essentially it sounds like you're asking if you have a warranty deed, what would that mean for inheritance purposes? Because this is posted on a video where I'm talking about a Ladybird deed and how when somebody in Florida has a Ladybird deed, they can list beneficiaries on their property so that the property would go directly to those beneficiaries. So in that instance, when you have a Ladybird deed, whoever is on the deed as a beneficiary is who ends up with the property, even if a last will and testament lists different beneficiaries. So the beneficiaries on the deed actually trump the beneficiaries in the last will and testament. So it's very similar to if somebody leaves all their money to a specific person or people in their will, but yet they put beneficiaries, named beneficiaries or named payable on death designations on each of their accounts. And if all of their money is in these accounts, then all of their money is going to the people who they listed as the beneficiary or the payable on death designated person on these accounts. It's not going to pass to anyone listed in the will because beneficiary designations trump a will. Again, the will is used for assets that are going through the probate process to determine who was going to get those assets at the end of probate. If you list a beneficiary or a POD on your account, or you get a Ladybird deed, which lists beneficiaries on your real property, all of those assets will then avoid the probate process and go directly to the people listed rather than who's listed in the will. However, a warranty deed is a little different. So a warranty deed is usually the type of deed that a buyer will request or will get usually when they're purchasing real estate. This is so they have a protection in their interest for real estate. What it does is it actually ensures that they're purchasing clear title. So a warranty deed means that the former owner of the property who's now selling the property to the buyer warrants that it's free of any title defects, even from before they bought it. So normally when you're purchasing new property, you want to make sure that there's no title dispute. That would be somebody else popping up and saying, hey, no, I really own the property. So often when someone buys property, they insist on a warranty deed. That way the person who's selling them the property would be responsible for anyone trying to make a claim saying that they owned it, which is why people do title searches, right? You want to make sure that the title is clear, that there is this exact chain of title and what the seller is selling, they actually own completely. No one else can make a claim against it. That way when they sell it to another person, right, when the buyer receives it, they can ask the seller to warrant the title, make sure that there isn't going to be anyone who pops up claiming that they own a portion of it. So that is what a warranty deed does. It just makes sure that if there's a title dispute, it's going to be the responsibility of the person who sold the property. It has nothing to do with inheritance. So a warranty deed doesn't list people on it who are going to inherit the property, unless, of course, they added the mom and your grandmother and your father added extra people to the deed who they wanted to inherit as joint tenants with rights of survivorship. Then it could pass that way. But if that's not the case, if the property is just owned by your dad and your grandmother, well, then either when both of them die, if they own it as joint tenants with rights of survivorship, or when either of them die, if they don't own it that way, which is called tenants in common, or if the deed doesn't say, just list their name, then a probate's going to be needed because a warranty deed doesn't bypass the probate process. So whenever that happens, either after grandma or dad dies or after they both die, the property will need to go through a probate process. And in that instance, whoever is listed in the last will and testament of either both of them or one of them, again, depending on if they're 50-50 owners or if they own jointly. Remember, if they're 50-50 owners, there's going to be a probate for dad's portion and a probate for grandma's portion. If they are joint tenants with full rights of survivorship, if they own the property jointly, there's just going to be one probate at the death of the survivor. So depending on what scenario we're in, we're either looking at just one will or two wills, and whatever that will says, or those wills say, is who the property is going to go to. So the will is going to prevail in this instance because there's no named beneficiary on the property. Again, a warranty deed doesn't list beneficiaries like a Ladybird deed or a transfer on death deed would do. Again, in those states that permit it. Florida does allow this type of deed. So when you don't have beneficiaries listed on the property, they're either going to pass to whoever you name in your will, or they're going to pass to whoever Florida law says inherits after you. So one or the other. In this instance, you said there's a will. They're leaving the property in the will to three people. So that's where the property would go at the end of probate, unless they decided to change this will. It sounds like maybe there's only one will, so obviously it's going to be important to find out how this property is owned. Do they each own 50%, or do they own it together jointly? That's going to determine whether it's smart to have two wills. They could always do a Ladybird deed too, and even if they own it 50-50, there could be two Ladybird deeds, one for dad's portion, one for grandma's portion. But as it stands with just a warranty deed, you're definitely going to be stuck with what the will or wills say, or if there is no will, even for a portion of the property, Florida law is going to say who inherits the property. All right, so I hope this answers the question. If there's any other question about deeds, Ladybird deeds in particular, estate planning, or any matters related to it, and you're in Florida, don't hesitate to reach out to us. We're at Cause Law Office, the non-stuffy attorneys, and the link is in my bio.